Hi, this is Steve Carlson. A couple weeks out from the election, we see a lot of things shifting, a lot of questions rising about some of Al Franken's positions, just how successful he's been. Tonight I found a little quiet spot. As I have mentioned, I have filed a lawsuit with the Minnesota Supreme Court and one of the big reasons why we need that lawsuit is so we can stop this practice of just randomly excluding candidates that might be an inconvenience for some of the Democrats and Republicans and their media friends from the debates, publicly broadcast debates. They just up and announce it. And I'm going to tell you, I mentioned earlier that the FCC is a big part of this. I can't believe this Obama FCC. I had to exclaim to the court in a motion I filed today, I'm amazed that the FCC now claims, this is for the whole country, this isn't just for my race, they're saying that the equal time provision basically only applies to paid advertisement commercials anymore. In other words, it's just a way to make sure that everybody gets to pay the media. Well, this is great for the FCC since that's what they are, the king of the media. But as far as the actual country, which they're not supposed to be king of, we're the sovereigns, that's terrible. We need equal time anytime there's debate. So we're going to get to that. But I want to read for you today from the motion that I filed. It has been accepted by the Minnesota Supreme Court. That doesn't mean they've granted it. It just means that they're going to look at it. As I understand, they're going to rule up and down on the merits. Can you exclude me from the debates just because there's no real reason that anybody needs to have fairness or equal time anymore? That maybe the First Amendment doesn't, it only applies to paid advertisement now? Who knows? But that's what I want to read. Now, I know I'm much more disciplined as I present this to the Supreme Court. So, and I think it's quick enough and to the point that you'll benefit from seeing some of the arguments that are actually involved in this. Petitioner, Steve Carlson, hereby moves the Supreme Court for an order enjoining WCCO, CBS TV, or WCCO, and the other participants, I'm talking about Al Franken and Mike McFadden, to include me in the U.S. Senate candidate debate alongside Senator Al Franken and Republican Mike McFadden. Said debate to be held October 26, 2014 and broadcast, and further ordering that should the debate not comply by including me in the debate broadcast, it should not be broadcast because it's a violation of the First Amendment and the equal time provisions. This is what I proposed to the Minnesota Supreme Court. This motion is brought pursuant to Minnesota Civil Rule 65, that's for injunctions, on the grounds that one, that first of all, the First Amendment protection of freedom of political expression and political association, which it turns out is not just a catchphrase. Two, Article 1, Section 3 is amended by the 17th Amendment, U.S. Constitution, providing that the Senate of the United States shall be composed of 2 senators from each state elected by the people thereof, okay, for 6 years. And those procedures are set up in our state laws, which are not being followed here. This directly guarantees the right to vote in the body of the Constitution. In other words, our right to vote is derived from the United States Constitution, not even the First Amendment. And the First Amendment gives us additional rights to vote that are related to voting. And 3, the equal time provision, 47 U.S.C. 315A, and its implementing federal regulations, which still require that a broadcaster like WCCO is not required to permit its broadcast facility and license to be used by any political campaigns, like Al Franken's or Mike McFadden's, as they intend to do on Sunday, on the 26th. But if that broadcaster does, it must extend the same equal opportunity to all legally qualified candidates. In this case, there is no legal distinction between myself and Senator Al Franken or Mike McFadden as candidates, since we are all major party nominees. Now, I make the distinction between the major party independents and minor parties like Libertarian who don't have the same rights. They have more rights. The Green Party just lost their rights as a minor party. But you get a write-in. This is not the subject of this, but it could be in the future. But what we have here is three major independent, major parties, and two of them are ganging up on the Independence Party. But we are all major party nominees, Mike, Al, and myself, because each of us has won the statewide party primary held August 12th. And that's an important point, I believe. So here's a memorandum. Okay, petitioner Steve Carlson is the Minnesota Independence Party nominee for U.S. Senator from Minnesota at the top of the November 4th ballot, facing incumbent Al Franken and Republican Mike McFadden. I have also on occasion been forced to argue my own cause in this court, Supreme Court, and other courts, but I'm not a lawyer. I had heard rumors that the Democrats and Republicans would try to exclude whomever they pleased from the Independence Party from political office campaign debates for this office broadcast or debate broadcast on FCC licensed broadcast media. And I had seen an opinion by some reporter that just because you're an Independence Party nominee doesn't mean you get to debate. And this would be a factor, they said, in the pending elimination of the Independence Party altogether. And now I learned that WCCO actually thinks these debates, which are part of the fundamental process of the people of Minnesota voting to choose the new government that will be formed by these national debates and these national elections, that this private commercial company thinks this debate is proprietary to them. That is to say, their own property to profit from. And so they get to edit it to enhance their own profits and goals. And in short, that they will, without the intervention of this court, air a supposed U.S. Senate candidates debate, including only the Democrat and Republican nominees, and exclude me from the election event. Now, in learning that media accounts were true, that these broadcasters of the U.S. Senate debates actually would allow Mike McFadden and Al Franken to negotiate their debates in order to help each other or help each of their respective campaigns, creating an unfair advantage by exercising power in the election over my appearances on public broadcast full debates, I immediately acted, being forcibly distracted from my campaign, as I am now, to address their actions which I've complained of here. I seek the aid of this court to enjoin them to include me in their October 26th broadcast debate through this motion for a temporary restraining order or preliminary injunction. I will serve WCCO with this motion and memorandum by emailing Esme Murphy, she's the moderator, and Jason DeRusha. I just happen to have his email. I have attempted to serve this motion and memorandum on WCCO by attempting to reach them by phone and by sending an urgent email at 10 o'clock this morning to moderator Esme Murphy and WCCO anchorperson Jason DeRusha. And at this point, have not heard from them. And by the way, I've never heard from them. I have asked them repeatedly since October 13th, 2014 to tell me if I am included or not, and to include me, presenting my formal qualifications under the equal time provision. On October 15th, 2014, I filed a complaint with the FCC seeking a ruling that I must be included. On October 20th, 2014, I received an FCC response. On October 19th, 2014, my laptop ceased to function, and at this point does not function. However, I am able to create a live session using Linux to run it, and I have learned that I may create documents such as this using Google Docs. Both of these things I heard about from my brother Marty, who is a member of Mensa and a computer geek, and thankfully I got them to work for me. And so I have worked strenuously to compose or recompose, since I lost all my data, my petition and to update it as events have changed. Because of the burdens on me as a candidate and as a litigator, untrained in the law, I struggled to get the petition filed and served on 11 respondent parties by mail and email in the case of Heather Johnson. And it ran up against the time constraints for this upcoming debate, scheduled on Sunday. I took a few hours break after getting the petition served and filed, and immediately am trying to get it before this court. The question of whether the law requires or obligates WCCO to include me as the major party nominee for the same office Al Franken and Mike McFadden seek. And I urge the court to issue an order that the law does require this. On October 23, 2014, petitioners served on respondents my elections petition seeking inter alia injunctive relief to orders WCCO CBS TV, that's a New York company, to include me in the broadcast debate for the office for which I am the Independence Party nominee. That is to say, the U.S. Senate, in the broadcast TV U.S. Senate debate to be held on October 26, 2014. As stated therein and in the FCC complaint I filed October 15th, I have been excluded by the Franken campaign or the McFadden campaign from any of the planning and had no communication from WCCO, although I contacted both Esme Murphy and Jason DeRusha to present my formal request and qualifications and credentials, which under the equal time rule governing broadcast debates does in fact require that I be included. I attached a copy of my FCC complaint to the elections petition I filed and served October 23rd, and that complaint includes a verbatim statement of that request, which conforms to all the requirements of 47 CFR 73.1940 legally qualified candidates for public office. The campaigns of my opponents for that office in the general election, November 4th, 2014, Senator Al Franken and his party, the DFL, and Mike McFadden, and a number of Minnesota broadcast media, including WCCO, CBS TV. This is Charlie Rose. I'm sure he believes in democracy. And Minnesota Public Radio, American Public Media of St. Paul, have colluded to create a false profile of my campaign as somehow not worthy of inclusion in any publicly broadcast U.S. Senate debates, and have taken a decision to exclude me from the 3 broadcast debates Minnesotans could get Al Franken to agree on. In Duluth, October 1st, Minneapolis, October 26th, and St. Paul, November 2nd. However, a Gravis marketing poll conducted July 2nd and 3rd showed me polling at 13% against Al Franken and Mike McFadden in a general election. So I do have significant voter support. In addition, the latest Survey USA KSTP poll of actual votes already cast shows that 8% of the voters voted for me, pulling 2% each from Al Franken and actually 1% from Mike McFadden. So while Franken is at 53, he only has 51% of the people who already voted, and McFadden has 36% instead of, and actually this should be 38%. While I have the 8% instead of the 3%, which the poll shows. Based on this poll, there is every reason to believe that if I perform well in these upcoming debates, if this court orders to allow me, I will easily carry the Independence Party to 2016. Hannah Nicollet, the other hope, is polling at 3% like I am, but only 4% of those who already voted report voting for her, which is under the 5% required to be a major party. And the court can see these poll numbers, and I give them the link. Now, I bring this motion to seek the aid of this court to enjoin WCCO, its partner, Hubert Humphrey Institute of Public Affairs, and Larry Jacobs, and the campaigns to include me in the debate October 26th under the jurisdiction and power of the First Amendment U.S. Constitution as codified in part in 47 U.S.C. 315 equal time requirement and its implementing regulations. and to declare that all such publicly broadcast debates, so that would be declaratory relief, must include all major party nominees for the general election. Discussion. Petitioner applies the criteria for issuing temporary injunctive relief expressed by this court in Dahlberg Brothers Incorporated versus Ford Motor Company, and argues why it is appropriate under these criteria to grant this motion for an order that I be included in the U.S. Senate debate. As stated in the motion itself, the grounds for issuing this order, whether temporary or at trial, are 1. The First Amendment protection of freedom of political expression and political association, as I said at the top. 2. Article 1, Section 3, as amended by the 17th Amendment, U.S. Constitution, providing that the Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, unquote. This directly guarantees the right to vote to each of us in the body of the Constitution, not requiring the First Amendment's additional rights to vote. And 3, of the equal time provision, 47 U.S.C. 315A, and is implementing federal regulations which still require that a broadcaster like WCCO is not required to permit its broadcast facility and license to be used by any political campaigns like Al Franken's or Mike McFadden's, but if it does, it must extend the same equal opportunity to all legally qualified candidates. In this case, again, there is no distinction legally between myself and Senator Al Franken or Mike McFadden, since we are all major party nominees, because each of us has won the statewide primary held August 12, 2014 by our respective parties. But the FCC has changed its policies, which now stand contrary to the congressional statute Section 315 as related to me. On August 20th, 2014, they showed me these new policies which contradict the law. And Mark Berlin, I call him Berlin, explains why the station does not have to include any candidates at all in a debate, or one candidate, for instance, just Senator Franken, or whomever Senator Franken chooses to allow, or just the Democrat and the Republican. That's because, says Mark Berlin from the FCC, broadcasters enjoy freedom of speech under the First Amendment, and the FCC is prohibited by statute from censoring or dictating program content. The result is that stations can pretty much air whatever and whomever they want, short of obscenity or indecency, even if the material is false, misleading, or slanted. Therefore, if the station chooses to include only 2 of the candidates in the debate, it can do so, and the FCC cannot tell it to do otherwise, unquote. However, this court, the Minnesota Supreme Court, can tell it to do otherwise. And I also disagree with Mr. Berlin, but this is Obama's administration. Mr. Berlin's argument that it purportedly follows from the limitations on FCC censorship or dictating of program content to the station, that the station in turn is allowed to censor me in candidate debates or violate the plain language of the equal time provisions as amended. This is contrary to law. The claim that Congress has created an exception so stations can eliminate legally qualified candidates at will or in the exercise of some kind of editorial discretion, which WCCO has not asserted, is undefended and indefensible. Mr. Berlin's response on behalf of the FCC is attached to the petition. I argue in the company of the United States Supreme Court on my side that the issue is not about what WCCO is allowed to broadcast as their own speech, but the issue here is their suppression and exclusion and elimination of my speech as a candidate for the same office, not what WCCO's editorial content should be. And no, given I note I can't do footnotes in this particular software at this time. Now, while I recognize some overlap between the First Amendment rights of WCCO and mine and that of the voters, the FCC in implementing equal time, and it appears sometimes they don't even change their rules, they just interpret them as they please, must not be allowed to supplant my rights with their rights. The FCC cannot interpret the equal time rule to supplant my First Amendment rights with WCCO's First Amendment rights, and by doing so, ignore the First Amendment or the equal time requirements. Now, Mr. Berlin's email includes this following statement, which I find absolutely astounding. Quote, the Equal Opportunities Law now largely pertains only to paid political announcements, unquote. He provides no support for this view. It's probably just a vote of Obama's appointees. These same people who Franken's working with, who supposedly they're going to get rid of net neutrality. They're going to allow people to sell the internet now. Not first Al's selling elections. Now Al and them are going to sell the internet to the highest bidder. Okay, this is a man, Al Franken, who does not believe in the First Amendment. This is the major problem that we face with this comedian in the Senate. Now, but let's go back to what Mr. Berlin said. In other words, we're talking about 30-second soundbite commercials like Franken's Bermuda and Ireland spots. So the FCC is contending that the First Amendment, as it is protected and regulated in political broadcasting, now applies only to those who can pay for it. This violates the First Amendment, and I direct the court and the parties to the famous case Buckley versus Vallejo, 424 U.S. At 1 from 1976. U.S. Reporters. You just go to volume 424 and you'll see it on the first page. Now, the First Amendment, this is reading from the Buckley Court. The First Amendment affords these expressions the broadest protection to such political expression in order to assure the unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Although First Amendment protections are not confined to the exposition of ideas, there is practically universal agreement that a major purpose of that amendment, the First Amendment, was to protect the free discussion of governmental affairs, of course, including discussions of candidates, talking about candidate debates. This no more than reflects our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. In a republic where the people are the sovereign, the ability of the citizenry to make informed choices among candidates for office is essential. For the identities of those who are elected, Al Franken will inevitably shape the course that we follow as a nation. They will pass laws which are binding on you and me, and yet we cannot even know about them, just like we couldn't read what was in Obamacare before it was passed by Al, because this is all like worked out by these great elite Democrats. Okay, the identities of these people will shape our future. As the court observed, it can hardly be doubted that the constitutional guarantee has its fullest, talking about the First Amendment and the right to vote, and most urgent application precisely to the conduct of campaigns for political office. Now, these people are running these campaigns into the ground. They're running over the First Amendment. I am asking the courts to restore this, not only for me, but to declare it must be restored for our democracy as a whole and all candidates in that democracy. Now WCCO seems to be saying tacitly, so as not to broadcast its possible reasons for its challenged actions, it has a right and support from this administration's FCC to put its own First Amendment editorial rights ahead of mine as the elected nominee of a major Minnesota political party seeking to have his views and positions included in a public broadcast debate for the U.S. Senate office. But the Supreme Court said in Buckley, citing Mills versus Alabama from 1966, that there is practically universal agreement that a major purpose of that First Amendment was to protect the free discussion of governmental affairs, not to protect WCCO. In fact, WCCO has that right, so it can cover government affairs. not to suppress and censor candidates it chooses to gang up against with the Democratic and Republican candidates. Thus, WCCO's selfish view would omit, at the very least, a major purpose of the First Amendment they tacitly rely on to exclude them. And Al relies on it to protect his bad jokes. Imagine, he could have got thrown off of Saturday Night Live if he did not have the First Amendment. So, again, it says, in a republic where the people are sovereign and not WCCO or Al Franken or Mike McFadden, the ability of the citizenry, that's you, to make informed choices among the candidates for office is essential. But here the people must guess what the other might have said if he had been allowed to participate in uninhibited, robust, and wide-open debate of public issues. The question is, does that profound national commitment to uninhibited, robust, and wide-open debate in this Senate election extend to this court, this Minnesota Supreme Court? I realize it does not extend to these self-interested partisans, McFadden and Franken, who feel they have an entitlement to power. This was used by Hannah Nicollet in the press conference the other day. I agree with that. But this court is relied on to protect that profound national commitment, no matter what you might think of me as a candidate or a litigator, which I am not. I believe First Amendment precedent requires this, and also that the equal time provision must be applied as it reads, and not be supplanted by Mr. Berlin's, the FCC's, new ideas about whether he can censor WCCO or not. That issue is irrelevant. No one is censoring that station. I am being censored and blacked out, and that is the only issue I wish this court to rule on in this motion. Does it violate these fundamental election rules to eliminate me from the debate? The First Amendment, United States Constitution, pertinently provides that Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble and petition the government for a redress of grievances. By the 14th Amendment, these restrictions are applied to state governments as well. We are in the process of forming a new government. This is a fundamental process to realize the Constitution. It's not overseen by the FCC. It's not overseen by Congress. It's a fundamental process which requires all three branches, the executive, the legislative, Congress, and the judiciary. And it also is delegated to this state to carry out these elections. And we have three branches, and the judiciary is key. We cannot have Washington, they call it the Beltway Beast, people like Al Franken, who's Washingtonized, coming in here and saying, hey, let's just cool this election out so no one will see what I'm actually doing or how it could be done just a whole lot better. And so we need to recognize this as a fundamental process. It's fundamental to realizing the Constitution because the Constitution does no more than establish the government. Without it constitutes the government. And to realize that, we need to establish a new U.S. Senate as a key component of the nation's federal government. So to suggest, as these broadcasters or the FCC or these Franken and McFadden campaigns do, that information on the candidates can be toyed with or manipulated or even withheld, as it is when I am totally blacked out of all the debates as I am at present. And it will not violate my rights or the fundamental rights of the sovereign people in establishing that government. It's untenable. I didn't want to be impolite. It's ridiculous. The First Amendment rights of legitimate journalists simply cannot be put ahead of either my rights as a candidate or the people's right to be informed. And certainly, when you've got talking heads governing the elections on TV, their rights don't go ahead of our rights to actually hear from the candidates or the candidates to actually express themselves equally. And this is what's happened with the equal rights, equal time. It is codified, the First Amendment, in order to respond to this, the rise of this behemoth media, this electronic media, which just gets into everybody's lives and everybody's minds and brainwashes you. And if Al Franken he's got his smiling face on there, but he's sitting there taking away your rights. He's sitting there passing Obamacare for Obama as a 60th vote. I mean, they came out to Minnesota and they recruited this SNL guy to push their agenda through. And you can see that from some of the pictures I have on some of my videos. So the primary purpose of the First Amendment as it applies to political decision making is to get information out to the public, not to censor it. As such, again, Congress in its lawmaking function has mitigated the obviously huge impact of these changes in society of the broadcast media and now the huge money, and maintained a national commitment to robust debates during elections by establishing two well-known acts. And one of them is the FCC Act. And I don't want to go too much into that, but I just want to kind of also mention that WCCO is imposing a kind of super primary of WCCOs to void the primary election by the actual voters. What we have in common, McFadden, Franken, and I, is we all won a primary. And anybody could have won that primary. I just happen to have won it, and I feel it a duty to the Independence Party, to the independent voters, and the Minnesota to defend that primary and not let it be voided by silliness in self-interest. And so if you look at Minnesota law, it says the manner of nomination. Candidates, this is 204B.03, candidates of a major political party, which we are, for any partisan office shall apply for a place on the primary ballot by filing an affidavit of candidacy, and except as otherwise provided shall be nominated by primary. So when we negate this nomination, we're negating Minnesota state law and the primary. But WCCO, Al Franken, and Mike McFadden, with the participation and sponsorship of the University of Minnesota, have ignored the actual primary, have voided Minnesota's primary elections, and will not put before the voters in what purportedly is a statewide U.S. Senate debate of the nominees their own preferred selection. They're now going to put their own preferred selection. They have eliminated me from their audience just as I eliminated Kevin Terrell from the actual Independence Party primary. To my knowledge, the equal time provisions have never been limited or overruled by the U.S. Supreme Court and still require, as such, my inclusion in these publicly broadcast debates in order not to offend the statutory requirements of those provisions, which provides that if any licensee shall permit any person who is a legally qualified candidate for any office to use a broadcasting station, he shall afford equal opportunities to other such candidates, all other such candidates, for that office in the use of such broadcasting station. Such licensee shall have no power of censorship over the material broadcast under the provisions of this section. So, as I read that, Berlin says he can't censor or dictate their content, but this law still says that WCCO cannot censor the material that is afforded by the coverage. This is a grant of trust that goes along with the grant of the license to somebody who's making a heck of a lot of money by selling commercial on the side. But this is a basic political purpose, and it's still protected by the equal time. And again, no obligation is imposed under this subsection under any licensee to allow in the first place the use of its station by any such candidate. They're talking about the first candidate, not the third candidate. Okay. Now, of course, they do, unless, of course, if they do permit one of the candidates, then there can be no argument that only Al Franken could appear throughout on these broadcast facilities, and yet this is what Mark Berlin said. This is how he's reading it. Now, these people are very confused. Now, these laws, as applied by the FCC, violate the mandates of the First Amendment, and further, because of the denials of free elections, petitioner is forced to take great measures during the election just to obtain rights I should already have had, time and resources that cannot be allocated to addressing the great issues of the 2014 Senate election. That in itself is a compounded violation of the First Amendment and other provisions requiring the U.S. Senator from Minnesota to be elected by the people, not by WCCO, Al Franken, and Mike McFadden. And in conclusion, this violates the First Amendment's protections as analyzed in Buckley. It violates the equal time provisions. It nullifies the primary elections. It impermissibly discriminates among the Minnesota major parties and puts the fox in charge of the henhouse, allowing private broadcasters like CBS, whose First Amendment rights are often touted, and allowing my rival nominees to make decisions to infringe on my First Amendment rights as a candidate to engage in this robust, uninhibited, and wide-open debate of the issues before the 2014 U.S. Senate election voters. Now here are the 5 Dahlberg factors. Petitioner is likely to succeed on the merits of this claim. The equal time provision is still good law. Unlike Randy Forbes in the Forbes First Amendment case, I have asserted and I am proceeding on my equal time claim because I exhausted administrative remedies, obtaining this opinion from Mr. Berlin of the FCC. I believe the equal time provision will be upheld in this case, and it should be upheld now. And WCCO can appeal if it wishes to litigate an absolute right to choose which primary winners it wants to include in the future. The balance of harms to myself, to the election, and to WCCO. There's actually no harm to WCCO if I'm included, because it is not their programming the voters are interested in, but our ideas, Franken's ideas, McFadden's ideas, and mine. It is likely to increase viewership and interest in the program if my views are included. And even Mr. Berlin agrees with this. Esme Murphy and the other moderators, Pat Kessler and Mr. Jacobs, still have control of the debate through their moderator rules. None of these respondents have any right to eliminate me that could be injured. There's no right of theirs that could be injured. It's just a fringe benefit for them to hog all the airtime. On the other hand, if I am excluded from this debate, that will make 2 debates of negative stories about we don't even need to include Carlson in debates. Why would you vote for him? We don't know what he stands for. It goes a long way to actually voiding the nomination entirely. It will leave more voters with more unanswered questions because the answers they're looking for were manipulated and shielded from them. My First Amendment rights to unfettered discussion and representation of my views will be lost. I will make movies about the debates, and it will be necessarily become one of my main issues, this First Amendment being taken out of our free and fair democratic government, which we yearn for. And I will be deprived of more opportunities to put forward solutions to lead this country, and to lead this country in this capacity of elected nominee. This will be lost forever. There still is one more debate, sponsored by respondent NPR and Al Franken and Mike McFadden. But that will have its own purposes and will not be suitable for redressing the wrong of the elimination and statements about me without my ability to respond in this debate. In other words, WCCO is making a statement about me. Because I can't be there to defend myself, I'm making this movie, spreading it all around the country, to tell you what WCCO really is about. Relationship of the parties, this is a third factor. The first 2 equities, I believe I've shown, weigh in my favor. This third equity, these 5 things are called equities because they're equitable factors that the courts use to determine whether they should undertake the equitable remedy of injunction. That's equitable, it's supposed to make things fair, maintain the status quo. Now, the relationship of the parties. The relationship here that WCCO and I share First Amendment rights with mine as a nominee is actually superior to theirs because mine are a protected part of a regime of a national election, and theirs is intended to allow that election to be free and fair and not constricted by the powers of government as to letting pertinent information leak out. they are actually carrying out the bidding of the incumbent party Senator Al Franken and their large party competitor and my competitor, the Republican Mike McFadden. Because of this relationship, they must not be allowed to make this decision, and they serve no constitutional purpose by eliminating me. Now, in public policy, without these free and open debates reflecting the profound national commitment to robust, uninhibited, and wide-open debates, there is no public here. This public is established, constituted by the U.S. Constitution, and the framers, the founders, and the Congress, in applicable enactments of law, have clearly established that protections against just this kind of infringement by political parties, broadcasters, enabled to make their living by an exclusive grant of the public airways, and others with pecuniary or political agendas, and it is most applicable, as the Buckley Court said, in political campaigns, and we need unfettered discussion. This claim by WCCO and Franken and McFadden are clearly aimed at fettering the discussion and violate public policy in the extreme. And finally, there is no administrative burden to order WCCO to include me in the debate. Therefore, all 5 equities of this Dahlberg analysis, which was established by this Minnesota Supreme Court, weigh in my favor, and I would urge them to allow me to change the subject and get in the debate and address the issues that are there, the reason we established this free government. Ebola, Obamacare. Ebola is actually worse than Obamacare. We're talking about ISIS, we're talking about terrorism, we're talking about a national debt of $17 trillion, we're talking about federal takeovers of education, we're talking about the loss of family rights, religious liberties, real opportunity to get real education, establish real families, get real opportunity to establish businesses, to serve your community, to get apart, to grow, to create the future. We're leaving our children, our generations with $17 trillion. These are the real issues. We got to get at those issues. But now I have to talk about free and fair elections. But I truly hope that this court will allow me on Sunday night or Sunday morning to be there with Al Franken and Mike McFadden and you and address these superior issues. I'm Steve Carlson, and I approve this message. Thank you for listening.